Welcome, everybody, to Engage in Trade. Today's topic is safeguarding intellectual property when selling abroad. My name is Susan Spitz, and I am the Manager of International Business Development here at the World Trade Center. And we are just very excited about this important presentation. In today's volatile climate of global trade, it's more important than ever for you to have a good understanding of the risks and the protections that are available regarding your intellectual property. And interestingly, even if you're not focused on overseas sales, if your products are made overseas, they can be at risk. And actually, even if they're made in the US, they can probably be at risk from anywhere in the world. So whether it's your ideas or your creations, there's a whole variety of things that constitute intellectual property. And our speaker today will cover all those types of intellectual property, identify the risks, and walk us through the various vehicles that are available to protect you and your creations. So just a few housekeeping rules to let you know about. All participants will be muted for the duration of the presentation, but if you wish to ask questions, please do so using the Q&A button at the bottom of your screen. We will do our best to get to those at the end of the presentation. And the slides and a recording of the presentation will be available. They'll go out to everybody who has registered about a week after the webinar has been completed. So let's see, I guess that's it for the housekeeping. And now it's my great pleasure to introduce to you the Deputy Director of the World Trade Center St. Louis, Miss Stella Sheehan. Ms. Stella Sheehan. She has been with the World Trade Center for over 18 years, and she leads our trade team, which consists of myself and Annie Mbali, who is our webmaster today. She has heads up our Executive Certificate in International Trade, which is our online export training. She oversees our 16 sister cities, and she's the executive producer of our signature event, Growing Global. Born and raised in Ireland, Stella has lived, worked, and studied extensively in international markets, including Belgium, France, Italy, and the UK. She holds a BA in French and Italian from the National University of Ireland in Galway, and an MA in Applied Languages for Business from the University of Ulster at Coleraine in Northern Ireland. And she is also a graduate of Leadership St. Louis and serves on the Missouri District Export Council as well. And as I always say, she is the wind beneath the wings of our executive director, Tim Nowak, who's in the audience today. Stella will now give a brief overview of World Trade Center's work and introduce our speaker. Over to you, Stella.
Thank you so much, Susan, for that gracious introduction. And thanks to all of you for joining us today on a snowy day here in St. Louis. What better day for a webinar? Safeguarding IP has, of course, taken center stage again in recent weeks, so this event promises to be both informative and timely. And as Susan said, we're very excited to be discussing this topic today. As Susan mentioned, I lead the trade side of the house, and we like to say that the World Trade Center has three main pillars: people, trade, and investment, the three key equal ingredients which go into making a global city. The people side consists of our 16 sister cities and perhaps our most well-known initiative, the St. Louis Mosaic Project, headed up by my colleague Betsy Cohen, which is an initiative to attract foreign-born to the region and assist them by way of programming and networking once they get here. The trade side provides companies with the tools they need to trade internationally by way of counseling, referrals to our federal and state partners, and organizing educational events like the one you're attending today. Last but certainly not least, our Foreign Direct Investment, or FDI pillar, led by my colleague Sean Mullins, assists companies around the globe who may be interested in setting up their North American base in the St. Louis region, while simultaneously assisting foreign companies who've already chosen St. Louis and wish to expand and continue to invest here. And now to the introduction of our speaker. Dan Crow is a partner with Brian Cave Leighton Paisner, also known as BCLP. He's been with the law firm for over 30 years, where he led the intellectual property client service group for more than a decade. And I would be remiss if I didn't mention that he came to us via his colleague and our WTC board member, Fred Bartelsmeyer. So big thank you to Fred for the referral. Dan represents both plaintiffs and defendants in patent infringement cases across a wide range of industries, including telecommunications, finance systems, automotive parts, consumer products, and medical devices. In addition to district court litigation experience, Dan has been actively involved in several inter partes review proceedings before the Patent Trial and Appeal Board of the US Patent and Trademark Office. He also has experience in trademark and copyright infringement cases, including non-traditional marks such as trade dress, product configuration, and product packaging. Additionally, he has extensive experience in opposition and cancellation proceedings before the Trademark Trial and Appeal Board. In addition to litigation, Dan performs global patent and trademark portfolio management, such as license agreements and IP due diligence in connection with mergers and acquisitions. Dan completed 2 Bachelor of Science degrees in 1986 in electrical engineering and computer engineering from Mizzou, followed by a Master of Science in electrical engineering from Missouri S&T and a JD from St. Louis University School of Law. He has been recognized by his peers with many awards, including several international recognitions within the world of patent law. In the US, he has received awards from Chambers USA and Best Lawyers in America and was named St. Louis Lawyer of the Year Intellectual Property in 2023. Over to you, Dan.
Thank you, Stella, for that. And so let me pull up my slides here to get started. Okay, so there we are. So we're here today to talk about intellectual property. I think the most interesting thing about intellectual property law from my perspective is it's the only area of law that I'm aware of that has intellectual in the title. You don't find that in real estate law or corporate law or personal injury law. Intellectual property is the only one. And so what is intellectual property? It generally can be categorized into 4 different areas, and we're going to touch on each of these areas today. I think for most of the presentation, I'm going to take the perspective that that I'm representing or working with a company in the US that is interested in either selling their products or offering their services outside the United States, or perhaps is having their products manufactured outside the United States, and what types of precautions you should take, and what can you do to secure and perhaps enforce your intellectual property rights. So those 4 buckets of intellectual property are generally categorized as inventions, which are creations of the mind. There are copyrightable works, literary and artistic works. There are trademarks, which could be in the form of a symbol or a word or some type of image. And there's also the sort of a catch-all bucket of trade secrets, which would be competitively sensitive information. And these 4 areas of intellectual property can overlap. In other words, you could have a single product or service be covered by multiple types of intellectual property. So again, I know that we have a wide variety of people in the audience. It looks like we have some lawyers, we have some business people that are engaged in international commerce. I think we have some students. And so I just wanted to kind of start off with sort of the basic groundwork so that we're all talking about the same thing. So you have patents, which can prevent others from selling their product or using their invention. You have trademarks. You have copyrights, which can include, I think for purposes of our discussion, not only artistic works like music and books, but also advertisements, software. Those can be considered copyrightable material. And then we have trade secrets. And I mentioned that it can overlap. And so, a relatively simplistic example might be a pair of tennis shoes along with the packaging that those shoes come in. And so you might have a design patent on what the bottom of the shoe looks like. It might be some kind of ornamental decorative component. You might have utility patents on how the shoe is manufactured and put together. You, of course, would have trademarks. You might have a copyright on an insert. You know, when you buy certain goods, sometimes it'll come with an insert that may tells a story about the product or something like that. And that could be copyrightable material. And then there also may be trade secrets. You know, it's possible that Nike has a proprietary method of attaching their sole to the upper portion of the shoe, and they might elect to protect that by way of trade secrets. So I merely put up this slide to just orient everyone that you can have multiple areas of protection for a single product or service. So we'll start off with patents. I think the important thing about patents is it is an exclusionary right. In other words, a negative monopoly. If you obtain a patent, it does not give you the right to do anything. It merely gives you the right to stop others from doing so or to license or otherwise authorize them. So an example of that might be, you know, if we think way back in time, and the only thing that people were sitting on were stools. And a stool had a seat and it had 4 legs. And you come along and you say, you know what, I can improve that stool by putting a back on it. And I'm going to call my new invention a chair. And my chair is going to have a seat, 4 legs, and a back. And you could get a patent on that, and you could prevent others from selling chairs, but you yourself could not sell the chair because the chair might infringe on the stool patent, because a chair, you know, by definition has a seat and 4 legs. So, and it's a simple example to try to indicate that, you know, many times when we're representing a company that might be acquiring another small business, and the small business will claim to have patents on their products, which is wonderful, but that doesn't answer the full question. You want to make sure that there are no patents that might, you know, otherwise cover the products that the company is selling. So, you know, why do companies obtain patents? Many times, you know, the overall guiding principle would be that to use your negative monopoly to try to prevent others from copying your inventions, from selling the same products that you've put a lot of R&D into developing. But also developing a portfolio of patents can be a way to reward your employees. It can be a way to showcase that your company is an innovator in the technological field. And then certainly there are companies out there who perhaps don't have the wherewithal or are just not successful in bringing products to the marketplace. And they could, you know, they might gain patents for licensing those out to others. Certainly that's a university R&D function model, is that they would develop patented technology and then look to license it out. So in order to obtain a patent, you do have to file an application with a governmental entity in the United States. That's the United States Patent and Trademark Office, which falls under the Department of Commerce, which of course has been in the news lately with some of the changes that the current administration is proposing. You know, a number of the patent examiners, the people who examine and allow patent applications, work remote. That's been a big development over the last 10 years for the Patent Office. And so if they, you know, enforce their requirement that they're talking about of having government employees come into the office, I think that really may impact the functioning of the Patent Office. So it'd be interesting to see how that plays out. So once you file your application with the Patent Office, they are essentially looking at 2 main requirements along with some other requirements. Those 2 main requirements are that your invention has to be new, So if we fall back to my chair analogy, there were only stools in the world. And so the fact that you're adding a back to a stool is new. So that would satisfy that requirement. The more difficult requirement to overcome is what is called non-obviousness. In other words, your invention cannot be obvious in light of the prior art. So the question is, would it have been obvious to add a back to a stool in order to form a chair? And that is something that either you or your patent attorney would argue with the patent office, have discussions with the patent office in order to meet that requirement. There's another requirement called disclosure. And just to contrast the idea of patents with trade secrets, which are secrets, everyone has heard that the formula for Coca-Cola was retained as a trade secret. Back when they decided to do that, they likely could have gotten a patent for that. But a patent under our Constitution is a limited right. It typically runs for 20 years from the day that you file your application. And according to the Constitution, the government grants patent rights in order to advance science. So one of the requirements is you have to fully disclose what your invention is to the public. In other words, you have to enable someone who works in your field to be able to make and use your invention without undergoing a lot of experimentation on their own. So you get this monopoly right in exchange for full disclosure to the public. The other approach might be to retain it as a trade secret, and that a trade secret has no time limitation. In other words, as long as you can keep your invention secret, your rights would last. And so going back to the example of the tennis shoe, and let's assume that Nike or another company had developed a new way to attach the upper of the shoe to its sole, and that manufacturing step would only be performed behind closed doors. And so Nike would be making the decision, well, once we start selling the shoes, could our competitors look at our shoe and reverse engineer it? And if the answer is no, they may elect to retain those inventive rights as a trade secret and not file a patent application. If they thought that there was a risk that someone could reverse engineer their idea, then they might opt toward patentability. So we talked, one of the main requirements is that the invention has to be new. And so novelty is typically based on what we call prior art, which is prior writings, earlier patents, trade journal articles, thesis statements, things of that nature. They can also be things that you generate about your invention, maybe a poster presentation at a trade show, demonstrations at a trade show. All of that can be what's called within the prior art. And in the United States, it's okay to take one of these steps. In other words, to publish your invention, show off your product at a trade show, write about it in a trade journal, call up the business journal and have them do an article about it. All of that is okay as long as you file your application within 1 year. So in the United States, you have a 1-year grace period before your own activities or the activities of others could prevent you from getting patent protection, because the patent office will say that it's no longer novel. That's not true outside the United States largely. So most other countries have what's called an absolute novelty requirement. In other words, you should not have a public disclosure that their citizens could access until you first have an application on file. So this is probably the first question that I think most patent attorneys would address with a client who they see, and she comes in and says she has an invention or she's had a product. And it's not, unusual for us to hear the story that she has been selling the product for 5 years, and all of a sudden it's taking off, and either she or some of her advisors suggest that she should obtain a patent. By that time, it's too late. So generally, once you make your invention known, once you start selling your product in the United States, you have to file that application within 1 year. There are, I think for purposes of our discussion, there are two general types of patents out there. There's what's called the utility, which most people refer to simply as a patent. There's also a design patent. The big difference is that utility patent protects the way an invention operates, whereas a design patent protects its ornamental appearance. So going back to my Nike shoe example, they might have some particular tread on the bottom of their shoe, might give it some kind of an ornamental appearance, and that may be the subject of a design patent. You do find design patents in footwear, you find them in automobiles quite frequently, you find them in products in your house, for example, light fixtures and lamps and other things like that. But the bulk of the patents are filed as utility patents. I mentioned there's a 20-year term for utility patents measured from the day that you file your patent application. And then we'll talk about two different types of applications, provisional and what they call non-provisional applications. So, the essential steps would be, you come up with an invention. You don't have to market your invention. If you happen to market your invention, you need to track that 12-month deadline. But then you would file a patent application with the patent office. You are not required to use a patent attorney. An inventor herself could do some research and file the application herself. You can also use what are called patent agents, which are people that have passed the requirements to practice before the patent office, but are not necessarily lawyers. But they can assist you with preparing your patent application and guiding it through the office. It typically takes anywhere from 1 to 3 years for your application to be examined and hopefully issued. You'll have some back and forth with the office in order to potentially amend your application or to argue with the patent office about whether or not you're meeting the requirements of novelty and non-obviousness. It also depends upon what technology your invention falls under. So in other words, your application is basically assigned to an examining corps who has a background in your invention. So if it's chemistry, electronics, communications, it'll be assigned to that group, and it really depends upon how busy that group is and how many examiners they have available. But typically, I think if you look at most patents that issue, it's around 3 years on average. Can certainly take longer, can certainly be shorter. There are also programs within the patent office to accelerate the issuance of your patent by meeting certain requirements, including paying some additional fees. And you might want to do that if your competitor is copying your product and stealing sales away from you. You can't sue them for patent infringement until your patent issues, so you might want to look for ways to accelerate that. Again, primary difference between a utility patent, which is something that is useful, versus a design, which is ornamental. So a couple thoughts on the patent application process. In the United States, a number of years ago, we changed the way we operate to come into compliance with the way that most other countries operate, which is we are a first-to-file system. So it matters who gets to the patent office first. So if you're coming up with an invention and you're working in Florida and you have no idea that there's another inventor working to solve the same problem in California, and you invent first, you come up with it first, but the person in California comes up with it second, but is quick to the patent office. If they're trying to get a patent on the identical invention, it would be the person in California who's entitled to it. So we're in a first to file situation now, so it is important that you get your patent application on file as soon as practical. There is a what some people might consider a quick and dirty step to get an application on file quickly. It's called a provisional patent application. I'll talk about that in a minute. And then the general process here for filing outside the United States in order to get protection outside the United States as a company that's based in the US and would likely file a patent application first in the US. You have then a 12-month period within which to file your applications outside the United States. And those non-US patent offices will consider the filing date of your application, for example, in Europe, to be the date that you filed in the US. There are, so within 12 months, you would perhaps file in Japan, China, Korea, Canada, Europe. Europe does have a regional patent office, so you could file one application in Europe and then ultimately with the goal of securing patent protection in whatever European countries you're interested in. There's also another process that we'll talk about. It's called filing applications under the Patent Cooperation Treaty. Stepping back to provisional patent applications, some people can think of this as a quick and dirty way to file an application. You do get the filing date. So if a client were to come to me and say, 11 months and 3 weeks ago, we demonstrated our product at a trade show, and, I understand there's this 12-month bar. Can I get an application on file, within 2 or 3 days? And the guidance might be to file a provisional patent application. Provisional patent application just preserves your filing date. It's never examined. It'll be automatically abandoned in 12 months. And so before that 12-month period expires, you must file, and I don't know who came up with these names, but they call it a non-provisional patent application. So it does have simpler filing requirements, lower governmental fees, and you're entitled to then advertise your product as something that is patent pending. Mentioned the Patent Cooperation Treaty. This is a vehicle to make it easier and potentially less expensive to obtain a number of patents outside the United States. So it is a single application that you would file. You can ask the entity to give an opinion, to do a search, and then to give you an opinion on whether you might be able to receive patents. And then eventually you would advance this application filed under the Patent Cooperation Treaty into whatever countries you are interested in. And I should have mentioned it, but maybe it's obvious by now, is that patents are on a nation-by-nation basis. So if you only obtain a patent in the United States, that gives you no rights in China, no rights in Europe. For whatever country you want to have those patent rights, those exclusionary rights in, you have to eventually file an application in those countries. The Patent Cooperation Treaty, I mentioned that there's a 12-month window from when you file in the US to, for example, filing in Mexico and Canada. This allows you to delay that for up to another 18 months. And so now you are 30 months away from when you filed your US application. And that can be a beneficial delay in terms of avoiding some significant costs for filing patent applications outside the US, but more so to give your team an opportunity to evaluate your product. Perhaps after 2.5 years, then whether this product is going to be successful, whether you might need to go back to the drawing board and make some tweaks to it. One of the largest expenses in filing patents outside the US is a requirement to translate into the local language, so to translate into French or Chinese or Korean. And those can be quite expensive. And I put a bullet on here that they're very important too. You know, many people take the quick route of translations, maybe do a Google Translate, or hire a very inexpensive translation services. That can have its downsides, because if you're working in the U.S. and you get a translation into French, you might not be able to read it, and the translator may have missed some key technical terms, which could, come back to bite you later in a litigation situation. Okay, so now we'll move on to trademarks. A trademark is a source identifier, enables consumers to readily know the source of the product. Unlike patents, there is no limit. As long as you continue to use the trademark, you can have rights in it. There are many different things that can be a trademark. Certainly words like Pepsi, symbols like the Nike swoosh. You can have colors. I think that that might be the UPS color brown. We've all seen the commercials of the duck quacking the word Aflac. That sound can be considered a trademark, and also scents. There's a company out there that makes fruit scented motor oils, and they can obtain trademarks as well, because when people hear that sound, or they see that color, or they smell that product, they know that it's only coming from one source. There are 4 general categories of trademarks. Generic, which tends to be the name of the product itself, something that is descriptive, like gas and go. That describes that you're going to fill up your tank and go rather quickly. So it describes the services. Mobile is an example of something that is suggestive. It certainly suggests a car or something that moves, but not necessarily gasoline. And then the highest protection would be for arbitrary or fanciful marks like Pepsi or Exxon. And in order to, I should step back. So as soon as you start using your trademark, you could, and as long as it is, suggestive or certainly arbitrary or fanciful, you have trademark rights. You can prevent others from using that same mark or that same logo for similar goods. You can also take the next step and register your trademark either at the state level or at the federal level with the United States Patent and Trademark Office. And then, of course, you can register your trademarks in foreign countries as well. Similar to patents, trademarks registrations are on a nation-by-nation basis. And so when we, many companies, when they're identifying their service, the marketing people want to come up with a brand that readily tells the consumer what it is. For example, gas and go. Fill up your car with gas and then you can go rather quickly. But from a trademark law perspective, you're much better off moving down this strength of protection chain that I have on this slide to something that is more suggestive or perhaps arbitrary. You're going to have a greater likelihood that your trademark is unique and you'll be able to get a registration for it. And you're also going to have less headaches in the future because people are likely not going to come up with the same brand that you have. In the US, there's 2 different types of trademark applications. You can file an application once you've already started marketing your product or your service. You can also, reserve your trademark, if you will, by filing an intent to use application, meaning I haven't started marketing my product yet, but I've developed a brand, I've developed a logo, and I would like to start that process. Very similar processes. You file an application. Again, you can use a lawyer. You don't have to. There are forms on the trademark office. It's relatively straightforward. And in order to finally obtain a registration, though, you do have to be using your trademark in commerce in the United States. So that if you were doing that before your application, you would file a use-based application. If you filed an intent to use application at a certain point in the process, you would need to provide the trademark office with evidence that you are using the mark. Outside the United States, the one caution I would have is that many countries are a first-to-file jurisdiction, and you can obtain trademark registrations in other countries without showing a use requirement, unlike the United States. And so what we find is that certain U.S. companies that will, eventually plan to sell their products outside the U.S. Have a challenge because someone has heard about their brand in the U.S. and they quickly run off in Asia or in South America. We see this a lot where they have filed a trademark application and you end up in a dispute trying to obtain your trademark rights in that country. So the key here would be to file early. Another suggestion for filing outside the United States would be to create for example, a Chinese language version of your trademark. And then, in China, you might want to file both your English language version of the mark that's used in the US, as well as something that you might adopt just for use in China. You can also record your trademark registrations with customs administrations, both in the US and with other countries that can aid in policing counterfeit goods bearing your marks either at the import or export level. In order to obtain a trademark registration outside the US, there's two primary options. One would be to just simply go to the trademark office in Canada, Mexico, China, and file an application with them. If you have plans to sell your products in, a large number of countries, that can be an expensive route. So there is an international registration under a Madrid protocol that the U.S. is a signatory to that provides a centralized application and maintenance, and you can reach approximately 130 countries in this fashion. Again, there are a benefit if you file your non-US applications within a certain time period of filing your US applications. In the case of trademarks, it's 6 months. So if you file your application in the US and then within 6 months you file in Mexico and in Canada, for example, you would get the benefit of your US filing date, and that might aid you in defeating some potential trademark squatters in those other countries. I'll move on to copyrights. Somewhat similar to trademarks, not really, but a copyright, once you sit down and compose a song, write a poem, you own the copyright in it. You don't have to do anything else. And in the US and most countries, you have then the rights to authorize others or prevent others from copying or modifying it or displaying it, performing it in some fashion. But you can take the step of registering your copyrights with the US Copyright Office, and that'll give you certain benefits. Large number of things that are copyrightable. Of course, I think most people think about artistic things, sculptures, paintings, books, movies, songs, but also advertisements and software are also properly the subject of copyright protection. What is not copyrightable? A short advertising phrase is typically not copyrightable. And an idea itself is not copyrightable. In other words, if you have the idea for how to come up with a new web page that is not copyrightable until you actually sit down and write the code to implement that web page. Copyrights belong to the creator in the first sense, and we do see a lot of companies fall into this trap where you hire someone else, even another company, to write software for you or to write a user's manual or otherwise develop copyrighted material for you. And most people just think, well, it's a work made for hire. I paid them to write that advertising jingle. I paid them to write that software. That's not enough. If they're an employee and they're doing so within the scope of their employment, that would be a work made for hire. But if you're dealing with a contractor or a vendor or someone who's not an employee, it's always the best practice would be to get an assignment from the software developer or the advertising agency where you own the copyrights in the materials. I think many of you have probably heard of the doctrine of fair use. Well, I can just pick off, some photograph that I saw on the web, or I can take some piece of advertising material I picked up at a trade show, and I can copy it and use it. I can use it in my PowerPoint presentations. I can put it on my website. That's not true. The doctrine of fair use is very limited. It's typically limited to where you're commenting or criticizing some copyrightable work. So in other words, someone who's doing a review of a movie is entitled to show short clips of the movie as long as they're creating some criticism. So I have the slide on here to just, people have heard about, well, I can use a portion of somebody else's copyrighted material because it's fair use. Not necessarily true. And I've listed some of the factors that would go into that. I mentioned that as soon as you create a creative work, you own the copyright in it. If you take the next step to register it with the Copyright Office, you can have benefits. You have to do so before you would file a lawsuit in the United States. It also provides you with evidence of validity. If you ever do get involved in litigation, the availability of some different types of damages and attorney's fees are only available if you register in a timely fashion. And I think there's many companies that take the approach that we're not going to register our copyrights in our software or in our user manuals or advertisements until we have an issue. And I think that's a defendable approach. It is a fairly simple application process, but many companies don't go through that process until an issue develops. Outside the United States, there's no international copyright law, but I think what you'll typically find is that most countries will enforce your U.S. copyright overseas. There are a number of treaties that the United States has signed up to. And so it is relatively easy to enforce a copyright on some material that you have developed in the United States, including software in other countries. I mentioned the work made for hire provision earlier. I think if you're going to hire, for example, software developers in a different country or other creative people in different countries, I think it is very important before they start that you understand what the law of that local country is. In other words, what do you need to comply with under Romanian law, for example, in order to own the copyrights in the software that your Romanian software development group, even if it's your own employees, is developing. I think I just have one slide on trade secrets. Trade secrets are a subset of confidential information. They are something that is secret, that has value, and that you've taken reasonable steps to keep it secret. So generally, you will lose your trade secret rights in your customer list, in your manufacturing process, if it becomes available to the public or could be reverse engineered. So I mentioned when Nike was deciding whether to retain their invention on how to attach a sole to an upper, whether they rely upon trade secret protection or take the step of patent protection. One of the key things would be, could it be reverse engineered? Could somebody figure out our secret in legitimate ways? So I think this is my wrap-up slide on considerations for developing a product or service in the United States, and then protecting your intellectual property rights outside the United States. Create a basket of rights. In other words, think about the product as a whole. Can I get patents on it? Can I get design patents? Are there copyrightable elements that I want to protect in that way? Do I have trade secrets? I want to make sure that I capture what those trade secrets are and make sure that they're kept secret, that my employees know that the company believes that they are a trade secret. And then particularly with respect to trademarks, for example, monitor, investigate, enforce. You do need to, take those steps in order to protect your intellectual property. In the United States, if you get into a litigation or a dispute over a patent or a trademark, you can have oral testimony in trial, but in many instances outside the United States, lawsuits are adjudged based on the written record, so not necessarily someone testifying. So it's important to keep documentary evidence of what your invention is, how long you've been using your trademark, who you might have shared your trade secret with under some form of an NDA. When you're manufacturing a product outside the United States, it's very, very important before any of that starts to have a good manufacturing agreement, good development agreement. And you want to have that agreement with the ultimate company that's doing that work. Many companies will use a sourcing agent. And, it's not good enough to have that agreement solely with the sourcing agent. You want to see what the agreement looks like with the actual company that's doing the development or manufacturing work. There's also a number of, sort of non-legal aspects that you might want to take to protect your intellectual property. We work with a number of companies that have their product manufactured in Asia, but they'll select a number of different manufacturing sites or entities to develop different parts, and then they'll have another company assemble it all together, so that no one company is able to has all the tooling in order to replicate exactly your product. If your product involves a microprocessor having some form of software loaded on it, you would certainly want to download that firmware elsewhere, maybe even in the United States, so that no one outside the US has access to your firmware. And then, another aspect is if you're having your products built overseas for the US market, you might want to consider controlling that importation, you being the importer. And therefore, you just have more control over which products and whether there are fraudulent products coming into the United States. So Susan and Stella, I think that that wraps up my portion of the presentation, and I think I can take some questions.
Great. Well, very interesting, and a reminder to folks to put questions in the Q&A section. I do see that there's one of the questions I also had is in here. Could I just ask on the end of your last slide, can you tell me a little more about what that means to control your imports? What did you mean by that?
Yeah, that you would be the importer of record as opposed to
Okay.
using some other entity
Got it. Okay.
as the importer.
Okay, thank you. So this first question, how is AI impacting the legal landscape surrounding IP? And of course, we know about lawsuits by, I think, like New York Times and companies suing the AI for using their information. So maybe you can speak to that or speak more broadly about it.
Yeah, I think it is impacting it. I think the Patent Office has a number of programs where they're using language models in order to help them search through a large amount of material when they're examining an application to try to decide whether or not your invention is new. They're typically looking at older patents, so rather than just doing a keyword search, they're using some some AI tools to help improve their processes. And I think with respect to some of the language models that have been trained on, New York Times articles, for example, to me as an IP lawyer, that is a copyright infringement because they are using the New York Times copyrightable material in order to create additional materials. And I think that as someone who, wrote those articles, I think that they have a right to feel like some of those language model developers are stealing their intellectual property.
Well, thank you for that. That's so you kind of hit both sides of it, right? Like the enforceability part, and then how the patent office is actually using AI to help their processes. Couple more questions that have come into the chat. Are there still process patents? For example, I worked with a pharmaceutical company that had a process patent on an iron supplement.
Yes. Yeah, so typically a process is a series of method steps. So, for example, you might get a patent on the article of manufacture, the chair. You might also have developed a really clever way to attach that back to the seat. And that is a series of steps that your factory workers are performing. And those series of method steps is called a process, and that is patentable. So, and
Great.
that could be, a method for creating a chemical formula, by adding this ingredient in first, heating it to a certain temperature, adding another ingredient, allowing it to cool. Those series of steps are certainly patentable.
Great. Is there any local company you could recommend to help someone get started with a new invention that they want to take to market? I think we could probably have some answers on that as well. Are there any folks you refer people to?
Yeah, I don't know that I have anybody in mind, Susan. I think your organization would probably be well suited for that. That's typically not a legal function. That tends to be more of a marketing function or product development
Yep.
piece.
Yeah, that there are actually a number of entities in St. Louis for helping startup companies, and they have probably those pieces in there too. So, Janetta, if you want to reach out to me separately, feel free to do that. I can make some referrals for you, but there is a lot of support in our region. I think we're pretty fortunate for that. Okay, and feel free to put some other questions. We got a minute or two more for the Q&A. Couple questions that I had was on the international, this would cover a couple of the different buckets, but on the international side, when you're protecting your product, are you just protecting its use within the region? For instance, like could a Russian company copy your product and sell it in the EU, but you have an EU patent? Like, do you know what I'm asking?
Yeah, exactly. So if you developed a product and you're selling it in the United States only, but you've obtained patents in the United States and Canada, for example,
Mhm.
you have, the thought that eventually you're going to be selling in Canada, but you've not started. And you notice that a Russian company has duplicated your product and started selling it in Canada. You could stop that, by going through the Canadian court system, or the Canadian Customs Office might give you some assistance. But if that same Russian company is selling your same product in Mexico and you did not obtain a patent in Mexico, can't do anything about it.
And you don't try to set up the patent in Russia to stop the Russian manufacturer. It's where the commerce is taking place.
Yeah, I
Right?
think that is a common question that we get, Susan. When we start talking with U.S. companies who have filed a U.S. application, they ask, well, where should I file internationally? And I think because it can be quite expensive. And I think the general guidance is wherever you think you're going to have significant enough sales, and also wherever you're going to manufacture your product. So if you're only going to sell in North and South America, but your product's going to be manufactured in Malaysia, you also might want to get a patent in Malaysia to stop either your vendor or another vendor from copying your product.
Okay, thank you. Okay, so we've got more questions. This is like, I could ask you questions all afternoon here, but I'm going to answer just one more question here. How do you clarify how to protect a corporate logo for a new company prior to filing a trademark? What constitutes use that would protect the logo?
Okay, so I think there's a couple of questions here, perhaps. So one would be, I've developed a logo. How do I know that it's not too similar to someone else's logo, or can I get a trademark registration? So there are groups out there that will do a trademark search. You don't have to work through an attorney, and they will search. We use them all the time. They will search federal trademark records, state trademark records, business directories, internet usage, and they'll produce a report for you that you could review. And you could say, hey, my logo looks pretty unique, or I didn't mean to, but I copied somebody else's logo in a similar field. So you can, it's always more important to clear your business name or your trademark rather than to file a trademark application, because you could still exist without a trademark registration, but once you start selling your product under your brand and you get that cease and desist letter, you're going to wish that you had cleared your mark before you put in all the marketing efforts. And I lost my train of thought. Susan, what was the other half of the question?
Well, I'm afraid we're going to have to stop here because we've only got
Okay.
2 more minutes and we've got to just talk about a few other kind of closing things. But thank you, everybody in the audience. It was good questions and great information, Daniel. I love the perfect tone of, not dumbing it down, but giving us, the basics so that we can understand what we have to look out for. So thank you so much for that. And so we, as I mentioned, we're going to be sending out a recording of this with the slides after the event. So you can be looking for that. And of course, there'll be information if you wanted to contact Dan for any of this, for follow on. We are very excited about the next couple of events we have coming up. The first one is actually primarily aimed at lenders, but companies are welcome to join us. It's the presentation by Exim Bank and the SBA talking about export financing. One thing to keep track of there, thanks, Annie, the export financing, some of those loans can actually be used for domestic issues now as well. So that's one of the things they're going to be talking about. And then, yes, the next slide, our annual International Women's Day event is going to be Tuesday, March 4th. And we are very excited about the 3 panelists that we have lined up. They're going to cover a good sort of variety of one's from academia, one is from in business, and one has done a lot of sort of strategy. I guess the slides are rolling here. So we're running out of time here, so just keep an eye out for that event. And if you're not already on our email list, you can go to our webpage, worldtradecenter-stl.com, and on the lower right side you can sign up for the email list. And both of these events are going to be in person. And just let us know if you have any other questions. Daniel, again, thank you very much for that presentation. And this concludes our webinar. Thank you very much.